Well, hello, everybody.
Case in point with Suzanne Sherman.
I'm fixing to commensurate this trial here. We gonna see if we can come up with a verdict up in here.
Well, hello, everybody, and welcome to a special edition of Case in Point. This is our second episode. If you missed the first one, you can get it on SoundCloud. That was with Marbury versus Madison with our special guest, Dr. Kevin Gutzman. I'm your host, Suzanne Sherman. You've tuned into the Cerberus Radio Network, where we defend liberty and freedom from the flames of tyranny. Joining me tonight in the studio is my producer and co-host, Jeff Johnson. You can follow us on Facebook, facebook.com/Cerberus Radio Network. We have a YouTube channel with the same name, as well as SoundCloud. We are on SoundCloud. You can download any of our shows for free. You can also share them. Again, we are very, very touched by the reception we're getting. The numbers are going up. The thoughts and the sentiments all of you are expressing to us. Jeff, I got to share one with you. I had somebody send me a message that said, I tune into Rush for entertainment, but I listen to Cerberus Radio Network so I can be educated. And, these are the messages we're getting. I want to talk tonight about Antonin Scalia and the case of the District of Columbia et al. Versus Heller. If you look to have a conversation with anybody about firearms and the Second Amendment, you can even go online right now and type in a query, the Second Amendment, and you are going to see Wikipedia come up or any other law journals that come up, and they will immediately go to what the Supreme Court has said. So I decided to take a look at what the Second Amendment really meant according to what I consider the landmark case in this issue, and that is Heller. So if you ask any gun enthusiast about the basis or origins of our rights, again, you're going to hear about District of Columbia versus Heller. This was decided by the United States Supreme Court in 2008. And as I mentioned, Heller is really touted as the vindication of the rights of lawful gun owners, as the District of Columbia has essentially at the time banned the possession of unregistered firearms, while at the same time prohibiting the registration of handguns. The city also required handguns to be kept in a non-functioning state when stored inside one's home, meaning they had to be kept unloaded and disassembled or bound with a trigger lock. The facts of the case are pretty simple. Heller was a police officer, and he sought to register a handgun that he wished to keep at home. The district refused to allow him to register the handgun, and he sued, citing the Second Amendment as the basis to stop the district from enforcing the ban on handgun registration. So we have here an issue of, I go on and on about the incorporation doctrine. We're not talking about that here. We're going to get to that one later on another show with regards to the McDonald case, which incorporated the Second Amendment against the states. But what we have here is essentially federal gun law. This took place in the District of Columbia. As we know, Congress was charged with the laws of the district. Interestingly enough, there was a case it was a February 21st, 1811. James Madison actually vetoed an act on incorporating the Alexandria Protestant Episcopal Church to become part of the District of Columbia, and he did so claiming it was a violation of the Establishment Clause on two fronts. You can read that on your own. You can also see that and read that for yourself in Kevin Gutzman's book, James Madison, Making of America. There's a topic on there. But we have to ask ourselves now, when I started talking about this case with you, Jeff, you brought up an interesting point as well. You mentioned that Congress really didn't have the authority, as we say all the time. Article 1 says all legislative powers shall be vested in Congress. Well, Congress has the authority over District of Columbia. What did you want to say about congressional authority? And we have a city council in District of Columbia.
Well, I said all along that I believe that Scalia missed the mark because he could have declared this law unconstitutional on Article 1, Section 8, Clause 17. It wasn't until 1973, with the District of Columbia Home Rule Act of 1973, that Congress delegated to a city council the powers vested in it in the Constitution by the states. I'm going to read that clause 7, just part of 17, because this is my whole point. To exercise exclusive legislation in all cases whatsoever over the district not exceeding 10 miles square, as may, by session of particular states and the acceptance of Congress, become the seat of the government of the United States. So the states granted to the Congress 10 miles square, and that to be the seat of the government and the legislative power over that 10 miles square. They didn't give it to a city council. They didn't make it a state. It is a District of Columbia, and the legislature was supposed to be the Congress, and they were supposed to take care of all the legislative needs of that district. By just giving it to the city council, they did something unconstitutional. They amended the Constitution without going through an amendment process. And since the city council is, the Congress, they are limited by the Article 1, Section 8, and they were never granted power over guns. So Scalia missed the mark in my opinion, all the way around, because he could have declared it unconstitutional a number of different ways, just using Article 1, Section 8, Clause 17.
And the interesting thing is, I asked Kevin Goodsmith about this, and he even said, yes, this transfer of power to the District of Columbia was what he said was dubious at best. And again, we see this time and time again when we have Congress coming up with an act that is tantamount to or a substitute for an Article 5 amendment to the Constitution. Well, we're just going to have an act instead. We don't have the authority, but we're just going to have an act. And this is the same thing with the Supreme Court. So, that being said, that was a really good point. I want to thank you for adding a little bit of depth. This episode is really following along with the article that came out recently in the 10th Amendment Center. And I did want to do a case in point. People have been asking about it. And I wanted to time it now also because Brett Kavanaugh's confirmation hearings for the United States Supreme Court are going to be starting, I believe, tomorrow. So getting back to this case here, Justice Antonin Scalia, he wrote the majority opinion, and the court here held that the Second Amendment protects an individual's right to possess a firearm, and that this right is unconnected with service in the militia. You can read the dissenting opinions that they believe that this right is only connected with some sort of military or militia service. But he said that it wasn't connected with service in the militia. And to use a firearm, the Second Amendment also guaranteed the right to use a firearm for traditionally lawful purposes, such as self-defense within the home. And gun activists cheered this decision. But should they have? And again, this is something we see when people really don't understand the intent of the Constitution and the federalist system we are supposed to have. Case in point, national reciprocity. I believe that just passed the House. People are cheering. They think this is a really good idea. I'm going to do another segment, a special episode on that as well. And I do have an article in the 10th Amendment Center called National Reciprocity is a Trojan Horse. If you have not read that yet, that will give you some more understanding as to where I'm getting here. Anyway, the Second Amendment, it states the following: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So accordingly, based on our discussion earlier as to jurisdiction and this being part of Congress, notwithstanding the delegation, we had said the unlawful delegation, unconstitutional delegation of authority to the DC Council, lawmaking authority in the District of Columbia was being granted this council by Congress is held to the same standard as Congress. So violations of freedoms include those in the Bill of Rights are properly deemed unconstitutional. Again, refer back to Madison's veto regarding the Establishment Clause violation if the Episcopal Church had been incorporated into the District of Columbia by congressional legislation. So going back to the Second Amendment, Justice Antonin Scalia really did not stop at what he felt the Second Amendment said. He took this opportunity instead to spread his intellectual wings and wax eloquent on matters that were really irrelevant to the purpose and intent of the Constitution as a whole, and to the Second Amendment in particular. He's frequently referred to as a textualist, meaning he relied on the plain words of the Constitution when it comes to determining what the document meant. His conclusion here, particularly in Heller, reveals the inherent problem with this method, and he failed to properly he did take into consideration, what I'm saying here is properly take into consideration the ratification debates and what was agreed to at the time. In other words, to what kind of government did the states and the people consent? Recently, Jeff, we did a show with our good friend Tom Mullen from the Foundation for Economic Education, and it had to do with consent of the governed, and what kind of government did we consent to? And again, we went back to look to see that by the ratification debates. James Madison in Federalist 45, he explained that the powers delegated to the general government were few and defined. Powers the states delegated to Congress are set forth in Article 1, Section 8, and other than the authority to arm the militia, there's no mention of regulating firearms anywhere in Article 1. But based on this clause, the power delegated to arm the militia, there were some at the time that feared Congress could either refuse to arm it or perhaps disarm it altogether. So the Second Amendment served two distinct purposes: to avoid the need to implement standing armies and reserving the states the authority to regulate arms in an effort to leave ultimate control over the government within the hands of the states and their respective people. This is a restriction. It was placed upon the federal government. It is reiterated in the 10th Amendment. What this means is that any regulations concerning firearms by Congress, and as in here, the District of Columbia, is unconstitutional. And this is the biggest misconception of the Bill of Rights, and that is that it grants rights to the people. The amendments were included to instill confidence in the states and the people of the beneficent ends of the new government, a sentiment expressed in the preamble to the Bill of Rights. Jeff, I went to UCLA. I had an undergrad degree in political science. Field of concentration was public law. I also have a law degree. At no time during either of those educational pursuits did we ever discuss the preamble to the Bill of Rights. The Second Amendment merely restates the lack of authority to regulate firearms, period. It's a restriction imposed upon the general government. So, keeping this in mind, let's examine Justice Scalia's analysis in light of the foregoing to determine whether it conforms with the intent of the ratifying states. In Section 2 of the court's opinion, he writes, "We turn first to the meaning of the Second Amendment, and this is the part where he could have appropriately stated that the purpose of the amendment was to prohibit any and all firearms regulations emanating from the general government, declared the district laws as violative of the Constitution, and simply stopped. Instead, his inquiry turned to which firearms are protected and whether their use and ownership rely on a connection to service in the militia, as well as an examination of the construction of the language of the amendment, which he refers to as prefatory and the operative clauses." And he explained that the Constitution was written to be understood by voters. Yet when I got the book, I got the opinion, you can buy it from Amazon. It's about 153 pages long. Justice Scalia himself took 64 pages to explain the meaning of the Second Amendment, which itself consists of one sentence. So the starting point, he said, is the presumption that the Second Amendment right is exercised individually and belongs to all Americans. This is where everybody cheers. But herein lies the problem. His starting point for this analysis is in direct contravention to the purpose and intent of the Bill of Rights. And that was, as I stated earlier, was to restrict the general government, When one classifies these restrictions on government as rights of the people, the doors then open to the government to control a policy matter over which they were never intended. Don't believe me? Well, listen up. I'm going to show you right now. Interestingly, he did acknowledge that the rights included the right does pre-exist the Constitution, and the right to keep and bear arms shall not be infringed. Yet here he contradicts himself. Go to page 22 of the opinion when he says that the Second Amendment conferred an individual right to keep and bear arms. Of course, the right is not unlimited. Well, here you go. So to claim that a right is so sacred that the government, may not infringe upon it, but then to say that the government has the authority to regulate the very same right is inherently contradictory. And we hear this all the time. We have these common sense gun laws. We have the Republicans. We have Donald Trump. We have the NRA, who are all supposed to be pro-firearms, pro-Second Amendment. Jeff, with all of these people on our side now and in control of the government, it has never been harder to get a gun. He quoted St. George Tucker, as did Carl Jones and I in our article on national reciprocity that was again published by the 10th Amendment Center. According to Mr. Tucker, whenever standing armies are kept up, and when the right of the people to keep and bear arms is under any color or pretext whatsoever prohibited, liberty, if not already annihilated, is on the brink of destruction. So, knowing that, any pretext whatsoever, we're going to see how, even though this appears at first glance to see a case that is in support of our firearms rights, it is really not. On page 44 of his opinion, he cites a case, United States versus Cruikshank. The court held there that the Second Amendment does not by its own force apply to anyone other than the federal government. And this quotation can only be interpreted to mean what was intended, again, that the Second Amendment is a restriction. It is one that does not apply to individuals, but to the general government. And again, Scalia says the Second Amendment applies to individuals in service and not in connection with services and militia. So accordingly, firearms are not subject to regulation by the federal government, not at all, not whatsoever. Section 3 of the opinion starts with the following sentence, and this here, folks, is an example. It's a perfect example why it is imperative to refer to the Second Amendment as a restriction and not a grant of rights. Like most rights, now I'm quoting him, like most rights, the right of the Second Amendment is not unlimited, meaning it is not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose, end of quote. Had the amendment been held to the standard as an absolute restriction against the general government, there would be no room to whittle away at this pre-existing right. Remember, I quoted earlier as his saying that this right is not unlimited. Well, it is. It's a restriction. It is a restriction to them. It is not a right for them to limit and whittle away and say is going to be subject to common sense gun regulations. As the jurist mentioned earlier, the right was antecedent to the Constitution and the founders and the ratifiers. They felt this at best that the general government have a hands-off approach in this area. There's another case that's cited in Heller, and that is the United States versus Miller, and that came in 1939. It was handed down, that opinion. And here he qualifies the types of firearms protected as those which were deemed to be in common use at the time. So also crucial to the Second Amendment right is the right to self-defense. He explains in section 4 of the court's opinion, the handgun, the primary focus of the law at issue, is the quintessential self-defense weapon. He describes how easy it is to store it in the home. It's readily accessible when you're needed. When it's needed, it can't be easily taken away. It's easier for those without upper body strength to use. Can be held in one hand while you call the police, and they're the most popular choice among Americans for self-defense. So here's another fundamental flaw in the interpretation of the Second Amendment. By focusing on the popularity of the handgun, he leaves open the possibility that other firearms may be considered to be outside the purview of the Second Amendment. Jeff, is this making sense so far?
Well, it's something we've been talking about for quite a while. The difference between granting rights and, oh, I'm sorry. I think you might be getting, are you getting an echo?
No, I'm fine.
Okay. I thought for a second there I have YouTube on another device to make sure everything's running perfectly. And tonight it is. And so anyway, back to what I was saying. We've been discussing this for quite a while. We've been discussing the difference between government granting and the government being restricted. And obviously, Scalia is of the opinion that government is giving out stuff and that they can take stuff away from you. And this is the danger, as we've talked about for months and months.
And as we know, those powers that were not delegated to the general government nor prohibited to the states remained with the states. That's the 10th Amendment, folks. And when we have this belief that the government can whittle away at a restriction on their upon them by calling it a right, we're going to see what happens after there's a shooting or any kind of violence, gun violence. We have the people crying, we have to do something. Well, this is what happened after Nicholas Cruz shot and killed 17 students in Florida, in the Parkland, Florida school shooting. We had a public debate, and predictably it turned to the issue of gun control, with specific focus on the ban of military-style rifles, or assault rifles, as they're also called. Carl Jones and I, by the way, also wrote an article concerning the proposed bans on the AR-15s, and you can find that also at the 10th Amendment Center. It's called Muskets to AR-15s, Weapon of War or Enemies of Tyranny. So missing in this public discussion was a crucial point that was the central reason for the ratification of the Second Amendment, and that's the people must have a means by which they can resist a tyrannical government. This means that are rendered ineffective if we surrender the right to be on a level playing field when rifles are not protected by the Second Amendment. What do you think she relied on? Heller. She said they may be lawfully subject to regulation and even an outright ban. So think about this. Because of Scalia's interpretation that only handguns were protected by the Second Amendment because of their popularity, and that they don't have to be connected with the militia, with service in the militia, that left open the door to imply that other firearms are not protected by the Second Amendment. So the Second Amendment, again, doesn't apply to any model or type of weapon. It applies to the general government. And these cases are showing us they are now trying to ban the very weapon that we say puts us on a more level playing field with the government. The amendment is not a means by which the right to keep and bear arms was granted to the people in the states. It is a restriction against the general government from prohibiting and regulating firearms at all. You're going to like this part, Jeff, because I'm going to quote a little Patrick Henry here during the Virginia ratification debate. He asked, "Of what service would militia be to you when most probably you will not have a single musket in the state? As as arms are to be provided by Congress, they may or may not furnish them." That's the end of that quote. This proclamation by Henry provides a succinct summation on the general beliefs of a large portion of Americans during the ratification period. This was a belief which led directly to the adoption of the Second Amendment. Remember, a primary concern was to ensure there be a means by which the people could resist a tyrannical government. The Second Amendment thus became It came about as a means of preventing the need for standing armies by keeping the militia, or as George Mason asserted, every able-bodied person under the auspices of the individual states, in other words, out of the immediate control of the general government. So to summarize, Justice Antonin Scalia acknowledges that the right to keep and bear arms is a right that predates the Constitution. He cites case law affirming that the Second Amendment was to apply to the federal government only, and he quotes St. George Tucker, who aptly stated that any infringement upon the right to keep and bear arms when standing armies are kept will annihilate liberty, by concluding that the district has a variety of tools to combat gun violence, including some measures regulating handguns. He first says that the right shall not be infringed. Then he says, but we're going to do it anyway. How the elected officials may deal with gun violence is beyond the purview of this episode. But when necessity requires action beyond the scope of the Constitution, then an amendment is required. A Supreme Court ruling is not tantamount to the Constitutional Convention, nor is an act of Congress, like you mentioned earlier with that 1973 act delegating authority to the Council of D.C. Yep, this is a practical effect of the decision, and in subsequent cases, language has been used to further limit gun rights at the state level. Again, like I said, we're going to get into that. When Antonin Scalia has implied that assault rifles are not subject to Second Amendment protection, which is, again, a total fallacy given the history and intent of the Constitution as ratified. Unfortunately, Americans interested in understanding the Constitution fall prey to those seeking to instill in their minds the necessity of an unlimited government. When the reasoning set forth in Heller is touted as an originalist view of the Constitution, conservatives especially are duped into believing that to preserve our liberties, we need to simply vote and hope for the next president to nominate, the Senate to confirm, and the right justice will be on the Supreme Court. As a result, now we're in the process of surrendering a fundamental tenet, our ability to defend ourselves from personal assault, as well as from a proven threat by the very government imposing these unlawful restrictions. They fail to realize our natural rights have already gone by the wayside, and we have admitted to being incapable of self-governance, and we have surrendered our revolutionary legacy. Ladies and gentlemen, we keep these episodes here on Case in Point to a half hour, and that's about it for us. Jeff, how much time do we have left? Did you want to comment in the few minutes we have?
We have about a minute and a half, and so I'll let you close it out.
Well, it's important that we look at these. It's important that we look at these cases in a way that is historically accurate, ladies and gentlemen. Again, I've caught myself before saying our Second Amendment rights, our First Amendment rights. When we call them rights and imply that they come from the Constitution or from the government, we have seen time and time again how the politicians say and the justices say these rights are not without reasonable regulations. We have to put back into the mindsets of liberty-minded citizens, not subjects, that these rights are non-negotiable. These are ours, independent of the government. The Bill of Rights here is a Bill of Restrictions. They should have called it that. Restrictions that shall not be whittled away. But we see the government all the time trying to grab more power from themselves and make us less able to protect ourselves from them. I want to thank you for listening, and please send me your comments on Facebook. You can also email me, Suzanne@Littell, LITTEL.com. I'd love to hear your comments. We appreciate everybody chiming in. Jeff Johnson, I want to thank you for producing my show. We couldn't do this without you. This has been episode 2 of Case in Point, the District of Columbia versus Heller, here on the Cerberus Radio Network, where we defend liberty and freedom from the flames of tyranny.